Hi guys, let's now discuss the price. We all know that the contract of sale has three essential elements. These are consent, object, and cost. And we all know in the contract of sale that the cost to the contract of sale is the price. So the law said that the price must be certain, otherwise it's void uh, for having absence of meeting of minds as to the price. However, in the following situation, price is considered to be certain. Okay, number one, there is an agreed definite amount to the sale, which simply means, let's say for example, a house and lot is offered for sale for a price of 1 million and the buyer take the 1 million. Okay, so there is a definite amount to the sale. Second one, it is with reference to another thing whose price is certain. So let's say, for example, I'm selling to you my only car, and I said, well, the price of the car is equivalent to the one semester tuition of LaSalle University. Okay. So, uh, in that case, though there is no definite amount stated in the contract of sale, still the price is certain because it is with reference to another thing whose price is certain. Number three, there is an agreement that the third person will determine the price. So let's say, for example, I'm selling to you my house and lot located in Makati. Okay. So then I said, we will have the register of deeds fix the price of the house and lot. Okay. So if the register of deeds fix the price, then the price is considered to be certain. Okay. The last one is that it is with reference to the price of the thing sold on a definite day or in a particular exchange or market. So let's say, for example, I'm selling to you a truckload of copra. Then I said the per kilo price of this copra is equivalent to the price of San Miguel Shares Corporation's uh, this day, May 27, 2020. So, in that case, then the price is considered to be certain. What if, for example, there is gross inadequacy of the price? So, let's say, for example, I'm selling to you the land which has a fair market value of 500,000 and I'm selling it for 300,000. Okay, so there is what we call gross inadequacy of the price. The law said it will not affect a contract of sale. So that's the general rule, except when it indicates a defect in the consent, like when it amounts to mistake, error, or fraud, on which case the contract is voidable. Okay. However, if the contract of sale was entered into to defraud the creditors, so I'm selling it for 300,000 just to evade the attachment of the property from the creditor, though the fair market value is 500,000, the law said the contract becomes a rescissible contract. All right? So, the last thing that we need to take into consideration is what if it is a simulated price, which simply means that there is no real payment of the price. It's a bogus sale. So, there is what we call a simulated price. So, the law said, well, the effect of that is that the sale is void and the parties are bound by their true intention. So let's say, for example, what really is the the true intention of the parties is really donation. Okay, then we make a contract of sale because before sale of donation of property to a person who is a stranger is subject to tax of 30%. And if I'm going to execute the contract of sale, then it's only subject to capital gains tax before of 6%. All right? So to avoid the tax, instead of executing the deed of donation before, I execute the deed of sale so that the tax that I will be paying is only 6% rather than paying donor's tax to a stranger of 30%. Okay, before the train law. So in this case, there is really a simulated price. And so the law said the contract of sale is void and you and me are bound by our true intention, which is really donations. So these are the things that we need to take into consideration when we talk about the price. Bye, guys.